Welcome to this presentation on the defence of consent. First thing that we need to sort out is that we are looking at a defence to non-fatal offences. We're not looking at the issues of consent around any sort of sexual activity. That's a completely different concept. So looking at the defence of consent, generally you can only consent to minor harm, and that consent must be informed and valid. But there are 5 exceptions in which you can consent to more than some harm, which are surgery, tattooing and ear piercing, horseplay, sports and sexual acts. So we're going to look at each one of these. Your consent can be implied, and the case of Wilson and Pringle held that what was described as ordinary jostlings of everyday life is not a battery, and that applies ordinary contact within contact sports. So when you get on the bus on the way home and somebody knocks into you, that's a risk that you consent to by stepping onto that bus. And those are the ordinary jostlings of everyday life. Now if you ended up with a really serious injury and somebody maybe saw a risk and took it anyway, that might be a different thing. But, small knocks, bruises, those sorts of things would be included in these ordinary jostlings. So consent must be genuine. And from this, it must be informed consent and true consent. So looking first at the idea that consent must be informed, this means that you need to know of the risk to which you are consenting. We look at the case of Dika. In this case, our defendant slept with women who didn't know that he was HIV positive. And the court held that it was no longer the case that consenting to sexual intercourse, the victims were also consenting to the risk of illness or injury. They couldn't consent to a risk that they weren't aware of. And if we also look at the case of Tabassum, in this case our defendant pretended that he was a doctor and carried out what he described as medical examinations on 2 women. His conviction for indecent assault was upheld on appeal because he deceived the women as to the nature and quality of his action. And we can compare Tabassum with the case of Richardson. In this case, the defendant was a dentist who'd been struck off but continued to practice. Initially, they were convicted of actual bodily harm, but this was overturned on appeal. This was because patients were aware of the nature and quality of the act the dentist was performing, and they consented to it. And it was not relevant that they would have refused consent had they known that she was no longer allowed to practice dentistry. And the other point is that consent must be true consent or valid consent. So in the case of Burrell and Harmer, the defendant was charged with actual bodily harm after tattooing a 13-year-old. Even though that 13-year-old gave consent, the consent was invalid as they didn't understand the nature of the act, especially the pain involved. And children need to be what's known as Gillig competent, meaning that they have to have sufficient understanding of what they are about to undertake. So, moving along, we have the general principle that the case of Pretty states that you cannot consent to being killed, and this includes euthanasia-assisted suicide. However, the case of Bland says family can consent to stopping artificial hydration and feeding. So these are moral issues that you might want to have a think about and you might want to reference in the appropriate place. In that Pretty wanted to give permission herself to somebody else to end her own life, and she wasn't allowed to do that. Whereas in Bland, his family were allowed to do that. So moving on to the exceptions. First exception is surgery. We don't have any case law here, but if you think about it, by consenting to undergo an operation, that's far more than some harm. That is serious cuts, that's serious bodily harm, yet you are consenting to it, and obviously you wouldn't be able to take your surgeon to court unless you hadn't consented. Also, tattooing and ear piercing. If we look at the case of Wilson, this extends the concept of tattooing and ear piercing. In this case, our defendant branded his initials with a hot knife into his wife at her request. So she did consent to the activity. Initially he was convicted, but his conviction was overturned on appeal because the court held that this was no more dangerous than tattooing, and the defence of consent was available for that. One of the other exceptions to the rule that you can only consent to some harm is in sport. If you're undertaking a dangerous sport, then you are consenting to possible risks. But those risks are only really associated with what is described as on-the-ball incidents. So if somebody in a football match goes to tackle you, it goes wrong and you get hurt, then you've consented to that possible risk. If you score a goal in football and somebody else doesn't like it and punch you in the face, you haven't consented to that because that would be an off-the-ball incident. And this is illustrated in the case of Billinghurst and Barnes. In Billinghurst, a defendant punched the victim in an off-the-ball incident at a rugby match. The defendant tried to argue that the victim consented by playing a dangerous sport in the first place, and the court held that this went beyond what was being consented to, and therefore no defence was available. In the case of Barnes, the defendant injured a fellow player in a football match, and the Court of Appeal said that we had to look at various factors when deciding if liability should be found, including the surrounding circumstances, the level of play, so is it a professional match, is it a children's match, the type and the amount of force, and also the defendant's state of mind. So moving along to the exception of horseplay or rough undisciplined play. This is essentially rough messing about. First case that we look at is the case of Aitken. In this case, our victim suffered serious burns after an RAF initiation ceremony, and the court held that the victim willingly participated, so the defence of consent was allowed. So these were military people in an initiation ceremony. In the case of Jones, the victim is thrown into the air by his classmates, and as he fell, his spleen ruptured. The court decided to allow consent because all involved, including the victim, thought that it was a joke and had consented up until the point where it all started to go wrong. Now, the case of Jones is accepted as the appropriate way that the law should work. This was teenagers messing about, they didn't see any risk, and something went horribly wrong. Whereas in Aitken, you have adults in a senior position in society who burns somebody through really, really reckless actions. And Aitken is quite a controversial decision for this reason. So moving along to the controversial one, you're going to have to put your seatbelts on for this one. So, sexual acts, you do and can consent to more than some harm, sometimes through sexual activity. If we look first at the case of Brown, in this case, the defendants, who were a group of gay men, were involved in sadomasochistic practices for sexual purposes. Sadomasochism is the giving and receiving of pain for sexual pleasure. Do not do a Google picture search of that. The victims were willing participants, and the court held that you cannot consent to actual bodily harm or grievous bodily harm for these reasons because it wasn't in the best interests of society. Now, this case provided the obiter dicta which was followed in the case of Wilson that we looked at a little earlier, where the defendant branded his wife with a knife. Commentators often compare and contrast these two cases in that they have quite a similar outcome. You've got Brown, where they're using pain for sexual pleasure, and you've got Wilson with the branding for sexual purposes. And the court held that Wilson was allowed because it was like tattooing. That's what the court said, that's not my opinion. Whereas Brown was purely for violent purposes, and we shouldn't be allowing people to carry out these very violent acts and get away with it. If we have a look now at the case of Slingsby, in this case the defendant and the victim had engaged in various consensual sexual activities, and whilst they were undertaking these activities, the defendant had been wearing a ring which had cut the victim. The cuts had become infected and the victim died as a result. and the defendant was acquitted of any responsibility around the victim's death, as he had not intended the injuries, and the acts undertaken were done so with the victim's consent. Now, if we look at the difference between these two, in Brown, the purpose was the pain and the injuries, where in Slingsby it was a completely unintended, unforeseen result. So now that we've looked at the defence of consent, you should be able to have a go at looking at consent in a scenario question. Remember, consent is a defence, and before you can establish a defence, you have to establish the offence first. So make sure that you pick out and fully explain and apply whichever non-fatal offence or offences are relevant before you establish your defence. So the question is to discuss Harry's criminal liability in respect of Javad's injuries for 25 marks. And the scenario is Harry and Javad were both 18 and they enjoyed skateboarding. They liked practicing tricks which involved narrowly missing each other at speed. Harry tried a trick that he had never been able to perform before, lost control and smashed into Javad. Javad's knee was dislocated, requiring painful surgery. So have a go at that scenario, identify the non-fatal offence around Javad's knee being dislocated and the painful surgery required. So another skill that you'll need is to be able to give criticisms and to note the evolution of the defence of consent. So there are lots of points, but this is just a brief introduction to some of them. So one thing to think about is the basis for allowing or denying consent actually clear? So the question, is it based on the level of harm that you cause, or is it based on the intention of the parties? Does the decision in Brown actually deprive people of their basic liberties? Lord Mustill dissented to the decision and said the state should interfere with the rights of individuals no more than necessary. He felt that not allowing the defence of consent was too much of an interference. And finally, is the basis for judging the validity of consent the identity of the person or the nature and quality of his act actually artificial? So how can the defence be available to Richardson, the dentist who'd been struck off, when it wasn't available to Tabassum or Dika? And does this not conflict with the idea of informed consent? So the Law Commission said that we needed to reform the law of consent, and they produced the Consultation Paper No. 139 in 1996 and suggested that we needed to modify these rules, extend the range of situations to which consent may be available, and remove some of the anomalies. Now this is 1996, this is over 20 years ago, and no legislative action has been taken on these proposals, although they may be good. So the Law Commission in their report suggested that the defendant should be able to rely on the victim's consent to an act intended to cause injury or likely to cause injury. They would keep surgical treatment as a special case, along with circumcision, tattooing and ear piercing, and they would adopt special rules in relation to boxing and other organised sports. However, they would not give special consideration to horseplay nor to sexual activities, and no defence to an act intended or likely to cause serious injury. So that's the law of consent, and you should now be able to explain the defence, you should be able to use it in a scenario, and you should be able to note criticisms and reforms